4, 3, 2, 1.
Good morning and welcome to the Money Matters 5th Annual Will and Estate Planning Forum. I am Kimberly Crabb-Adams and I will be your moderator for the 2 exciting sessions that the organizers have planned for you this morning. Now, I am to introduce myself, which is sometimes a difficult task because there's just so much to say, but in the moment you just don't know what to say. So in short, like all of the panelists here this morning, I am a lawyer. I've been practicing for 13 years with Harney, Westwood and Regals in the Litigation Dispute Resolution Department, and I do not specialize in estate planning. And so like many of you here this morning, and those who have joined us virtually, I am very excited to learn and to hear what the panelists have prepared for us this morning. Now, we have 3 panelists for our first session, and I will begin by introducing the lady to my right, Miss Anthea Smith. Anthea is the managing partner at Sables Law and has been in the legal arena for 30 years, with 23 years of practicing in the BVI. She has extensive experience in courts and regularly advises businesses, business persons, and individuals in the BVI. Her practice areas include property, banking, wills and estate planning, probate, shipping, and admiralty, as well as civil litigation. Also to my right, we have Mr. Jack Husbands. Mr. Husbands has been practicing law in the BVI for over 30 years. He is a fellow Chartered Institute of Arbitrators. He's a fellow of the Chartered Institute of Arbitrators, a trust and estate practitioner, and a member of the International Bar Association. He also sits part-time as an additional magistrate and as chair of the Arbitration Tribunal. And last, but as the saying goes, by no means least, we have to my left, Mr. David Bednigo. Mr. Bednigo is the managing partner of Harbour Chambers, and his legal profession spans over 26 years. In former years, Mr. Abednego was the official receiver of the Virgin Islands, and his current practice includes regulatory advice on financial services legislation to BVI-regulated entities, providing insolvency advice to both regulated and non-regulated BVI companies, property law, with a great emphasis on residential property, and raw land acquisition and disposal. Now, before we get into the meat of our discussions this morning, a few housekeeping rules. The restrooms, for those in person, are, if you go through the back door to your left, they will be in the corridor just before the elevator, the men's, and right after the elevator, the women's. Phones, please, could we put our phones on silent or vibrate? And questions, we have a specific designated period after all the presentations and questions have been answered that I will ask to the panelists for questions to be answered. And lastly, and this is a reminder for myself as well, we have a Spanish translator on one of the channels, and so for all of us, just be mindful to speak audibly and a little slowly so that the translator can do his thing. Now, the outline of the session this morning, I will ask the panelists questions and they will answer, and then we will open the floor for the questions at the end. Now, I will begin by asking the first question to Mr. Abednego, and my question is, in layman's terms, could you tell us what a will is and how it works?
Thank you, Madam Chair. In layman's term, a will, or also called a last will and testament, is a written legal document or a written statement that outlines a person's wishes for the distribution of their assets and possessions after their death. So a proper will should specify who will inherit your property, who will manage your estate, and any other relevant instructions, such as guardianship of children. A will really works by the fact that it takes effect after your death. So it's always important to understand that with the will. A will takes effect after your death. So it can be a living, breathing document. So as things changes in your life, whether it is you acquire new assets or new persons come into your life or come out of your life, you're able to make amendments to your will because it does not come into effect until the point of your death.
Thank you very much. And moving on from that, could you tell us if there are different types of will?
Yes, there are different type of wills. Oftentimes, I have clients will ask me or say to me, I want a will, and I want a simple will. They would use that term, a simple will. And I don't have a definition of what a simple will is, but I certainly take a simple will to mean it is your wishes where you do not have a lot of specific instructions. You do not have a trust in your will, as an example. It may be a simple thing, such as a husband saying, I leave my estate to my spouse, or a wife saying, upon my passing, I leave my estate to my children. So, I consider those kind of provisions, simple provisions, so a simple will. Then we have what we can call a joint will. A joint will, as an example, is where you have husband and wife preparing the same document together. And in that, you may have two major provisions where one of the provisions would say, if the first person to die, upon the death of the first person, then the entire estate goes to the other spouse. And then the second provision, where the surviving spouse says, upon my death, then my assets will go to my children. So it's a provision like that. So that's a joint will, where both spouses have signed this document. Then we also have what is a reciprocal will or a mirror will. And using husband and wife once again as an example, a reciprocal will or mirror will, both persons are on the same page, and each will is very much the same, mirrors each other. So usually with the same wishes, I leave my estate, as an example, to my spouse. If my spouse predeceased me, I leave my estate to my children equally. So both wills will have those same provisions. So they're identical to each other, but they are individually placed. In one of those, one spouse would be the executor of the other's estate, and vice versa in those estates. So that's a reciprocal will or a mirror will. Then we also may have what's called the testamentary trust will. And in that will, as an example, is where we can say, the husband say, I leave my estate to my wife in trust. My wife will be the trustee of that trust after I pass. During her lifetime, she will receive any and all income from that the trust may produce. And upon her death, any trust income shall then pass to my children. So those, and a simple example such like that, you may find in a will that's a testamentary trust will. Now there's also something else we speak about that's called a living will. Now, a living will is not really a will, as we would call it. Because remember now, a will is a document that comes into effect after you're dead. This document that's called a living will really is a document that speaks to end of care. If, as an example, you find that you become what we call a vegetable, you find it's in a vegetative state and decisions need to be made, this document gives guidance to your caretaker, your doctor, in terms of whether it is you want to, how you want to live the end of your life. Is it that you want to remain on a machine, or you want the plug to be pulled, or die a natural death? So that's really what a living will is all about. So it's not really a will, strictly speaking, but it's instructions, a document that provides instructions. Should I be in a situation where a decision has to be made in terms of whether I need to remain on a machine for the rest of my life, or whether the plug be pulled, what my options are, what I would want. So it helps that person who is making that decision, help them make that decision a lot easier. So those are your basic wills.
Thank you very much, Mr. Abednego. And now I will turn to you, Ms. Smith. Why would you say it is important to have a will?
Thanks, Madam Chair. A will is a written legal document, and once you have that, it gives certainty to how you want your assets to be distributed upon your death. So I would say the main importance of having a will is certainty. You get to dictate how your assets are distributed. You get to indicate in that document your preferences. You basically call the shots. In the absence of a will, the shots are going to be called otherwise. The usual clashes of mommy or daddy told me they wanted this to go this way, or with another sibling and other siblings saying mommy or daddy wanted it to go another way, that's eliminated because you have a written document that says exactly how the estate should be distributed. So it also reduces the likelihood of family and other disputes as to what the person would have wanted, because you have a document indicating where that person indicated everything that they wanted to take place upon their death. So the certainty is there. I should add here why it's important. On the BVI law, if you don't have a will, then you do have law in the BVI that will determine how your assets are distributed. So persons need to know that if you don't leave a will, BVI law will say how your assets will be.
You may not like it.
And you may not.
Well, you won't be around, but
You may or you may not, but you won't be around. But it will then there will not be certainty as to what you exactly wanted, how you wanted things to be distributed. So that's the importance of a will.
And to you again, Ms. Smith, for someone who wants to get started making a will, what documents would they need?
Well, it depends on, firstly, you have to assess what your assets are. And if you have property, if you have land, one of the things you will want to do is obtain from the land registry, the land register for your properties. Or if you don't have that, you can just make sure you know the parcel and block number in the registration section so that the lawyer can obtain it for you, because it's very important for the lawyer to ascertain how that property is owned. Is it owned by you solely? Is it owned with other persons? Is it owned jointly or in common? So the lawyer can know and be able to advise you as to what can and cannot be included in your will. You may have shares in a company. It would be wise to have a copy of the share register so you can take to your lawyer so your lawyer can know how those shares are held, how many shares, and they will be able to advise you again how you can make provisions for that. You may have bank accounts. It may be important because depending on how you own the bank account, if you own it joint with somebody, as a lawyer would have to advise you. So you may want to walk with a document or the statement that shows how the bank account is set up, so that the lawyer can then again advise you as to how you can make your will in relation to that particular bank account. Because as lawyers would know, laypersons would not know if you own certain things jointly, the law says what is to happen or what is not supposed to happen in relation to your will. So it's important for the lawyer to first know how you own your assets. There may be other assets you own that there are documents in relation to. I mean, people have different fetishes. I have seen persons who have gold and they want to leave that for someone and they have a document saying the weight of that gold, etc. As I said, different folks have different fetishes, and if there's a document that shows the asset you own and different details about it, you may want to present that to the lawyer as well.
Thank you. So if you have diamonds, you need to say, honey, I hope you're listening. The diamonds, you have to say who gets the diamonds.
Well, you should. As I said, if you don't say, if you're allowed to say, who would get it?
Thank you, Ms. Smith. Now, Mr. Husbands, this is for you. What are the local requirements to write a will?
Yes, the local requirements, thank you. The local requirements are quite simple, actually. You need to, the will needs to be in writing, and it needs to be witnessed by two individuals. And the individuals and the person who's making the will must be present, all three of them together, when the will is executed, when the will is signed, and it must be signed in the presence of each other. It can't be signed by round robin where I sign and then send it to you, and you sign and send it to the other witness. They must all three be together in the same room and watch each other sign. So that's the basic requirement. The person who who is a witness should not be a beneficiary getting the property under the will. That should be a non-beneficiary. I like to think that the witnesses must be persons probably, well, if the person who's making the will is a certain age, it would be good to have witnesses who are younger than that person, because you want your witnesses to survive you, and you want to increase the chances that your witness will survive you and be able to verify that the will was signed and so on. Similarly with your executor, you would want your executor to survive you. So it makes no point providing as an executor somebody who's really old if you're very young. So those are the basic requirements for making a will. It must be in writing, it must be signed in the presence of two witnesses. So that's about it.
What about age? Is there an age requirement to making a will?
No, there's no age requirement. But I'm glad you mentioned that, because the person must be of sound mind, must be what the law calls legally competent. That means they know what they're doing, they know if they're making a will, they know who the beneficiaries are, they know what property they have. So they must have, so people who suffer from dementia, there's after a certain point where you can't make a will because you don't have the necessary mental acuity. The thing about the lawyers who participate in making the will is very important. This process should be overseen by the lawyers. So a lawyer making a will of a person of a certain age, or if the lawyer, even if the person is youngish, but the lawyer sees some reason to think otherwise, the lawyer should ensure that there is medical evidence. The person is seeing a doctor, a physician, for a competence test. And the courts have been very hard on lawyers who go ahead and get wills made when they ought to have. There's no hard and fast rule, but you know it when you see it, Or the person may be under the control of the beneficiary, and the beneficiary may be in the same room. So the lawyer ought to take confidential instructions from the person making the will outside of the hearing and so on of the beneficiary or the person who is contacted the lawyer to make the will, because it may not have been the person who wants to make the will who contacts the lawyer. So there's a heavy burden on the lawyer to make sure that the person has the necessary mental acuity to be able to make a will.
Thank you, Mr. Husbands, and that feeds right into my next question. Is a lawyer absolutely necessary in the making of a will?
No, a will is a fairly simple document and you can make it yourself. There are templates around and you can fill out the template, and once you know that, you must sign it in the presence of 2 witnesses, you name an executor. From the template, it is not difficult, although it is advisable to get legal representation. More complex wills that contain trusts or other, other ways of leaving property and so on, should definitely be done with the advice of a lawyer. You should make a will with a trust in it from a template. You should get legal advice. So the more complex the will, the more is the need to have legal advice. But a very simple one-page will, I leave all my property for my wife, blah, 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 that's it. You probably don't need a lawyer for that, if you have a good template.
Just to assist, Madam Chair, following up on what Mr. Husband is saying, with what we call a homemade will, if it is that you're doing a homemade will, it's also important to understand with your witnesses that if the person witnessing your will, you can't be given a gift to them.
Yeah.
So it's knowing the qualifications. It's one thing to do what we call a homemade will, will which you do yourself, but also knowing the requirements. So if you have your witnesses, those individuals can't be persons who are benefiting from the will. So just certain key provisions are also important for a person doing a homemade will.
Yeah. That's why I always advise people to have wills prepared by lawyers. Some people want to save a buck here or there, they want to do it themselves. So if they get a draft of a will from a trusted source, maybe they can do it. But they shouldn't draft it from scratch themselves.
Thank you, Mr. Husbands. Now, Mr. Abednego, once valid, what should you do with your will? So once you've prepared it and it's a valid will, what should you do with it?
So you've prepared your will, you have it's properly executed. One of the first things you should certainly do is secure your will. Place your will in some form of storage. And whether it is, as we have here in the BVI, you can register your will at the High Court. It's virtually free. I think that the only fee is the stamp duty. It's $3 or something like that. So it's virtually, it's minimum cost. You could have a copy there, be registered there. If it is you're at home, you have it placed in a secure, safe box.